Assalamualaikum warahmatullahi wabarakatuh. My name is Fatima Azzahra binti Muhammad NIZAM and my metric number is 1202145. And today our group will be presenting the topic of a critical analysis on the legislative and judicial powers of the Yang di-Pertuan Agong and their significance. Now let's proceed to the introduction. Okay, as we know, as a constitutional monarch, the YDPA reigns, however he does not rule. He is the head of the state as provided in Article 32, Clause 1 of the Constitution. And according to the article, the Yang di-Pertuan Agong has precedence over all persons in the Federation and is not subject to any actions in any court except the special court. And the YDPA is elected for a 5-year term by the Conference of Rulers among the 9 Malay rulers in rotation. This is provided under Article 32, Clause 3 of the Constitution. And the Yang di-Pertua Negeri in the 4 states without a king, which are the Melaka, Sabah, Sarawak and Pulau Penang, on the other hand, cannot become a YDPA and cannot vote in the YDPA election. This system of rotating the YDPA office was introduced to ensure rotation of the office between the states and was recommended by the Reid Commission, who believed that the YDPA would be a symbol of unity of the country. Next, the power and functions of the YDPA. According to Article 40, Clause 1, in carrying out his duties, the YDPA must accept and act on the advice of the Cabinet or a minister acting under the general authority of the Cabinet. And there are a few case laws to support this view, which are Datuk Seri Anwar Ibrahim and Perdana Menteri Malaysia, and Stephen Kalong Ningkan and Tun Abang Haji Openg. However, under Article 40 Clause 2, the YDPA also may act in his discretion in a few matters, such as the appointment of a Prime Minister, the withholding of a consent to a request for the dissolution of Parliament, the requisition of a meeting of the Conference of Rulers concerned solely with the privilege, position, orders and dignities of their Royal Highness, as well as any action taken at such a meeting, and many other cases mentioned in the Constitution. So we can see that the overall constitutional position is that the YDPA can perform two sorts of functions, which are non-discretionary functions on advice and a small number of critical discretionary functions. Now let's proceed to the legislative powers of the Yang di-Pertuan Agong. The YDPA legislative jurisdiction is provided under Article 44 of the Federal Constitution. The YDPA, along with the House of Senate and the House of Representatives, is one of the 3 constituents of the Parliament. The Federal Constitution has listed various functions of the YDPA that affect the legislature, including the first one is approving a bill passed by the 2 Dewan. The main function of legislation to the YDPA is to sanction the bill enacted by the Parliament. According to Article 66, the YDPA is responsible approving a bill passed by both houses, which are Dewan Rakyat and Dewan Negara, before the bill being declared a valid law, which means that all law enforcements approved by the parliaments needs the recognition of the YDPA before it being enforced. However, Article 66 Clause 4A provides that the YDPA must assent to the new law within 30 days of its becoming law. Otherwise, it becomes law as if he had assented to it. And if he does not agree with the bill that was passed by the Parliament, he has 30 days to return it to the House where it was originated. And he must make an explanation of his grounds for objecting the bill or any provision in it. And if the bill was passed by both houses again, it will become law automatically if the YDPA did not consent to it within 30 days of its presentation. So we can see that there are 2 effects of the amendment on Article 66 Clause 4A. The first one is the power of assenting the law has been reduced on the part of the YDPA. His powers were restricted in the Constitutional Amendment 1994, which stated that he must assent to a bill within 30 days or else it becomes law as if he had assented to it. And the second effect, we can see that a bill can be easily passed in Malaysia. This is because The bill can be implemented as law and written in the Federal Constitution as a recognised law, whether the YDPA agree or disagree of the bill after 30 days. The second legislature function of the YDPA is that the YDPA can summon, prorogue and dissolve the Parliament. According to Article 55 Clause 1, it provides that the YDPA can summon the Parliament from time to time, and the YDPA can allot a period of 6 months between the last proceedings in one term with the appointed date for the next meeting for the following term. And according to Article 55 Clause 2 and Article 40 Clause 2b, it provides that the Yang di-Pertuan Agong also has the authority to dissolve and prorogue the Parliament. The King has the power to refuse a premature dissolution of the Dewan Rakyat. Thus, if a Prime Minister loses his majority in the House and wish to return to the people for a fresh mandate, but the King is satisfied that an alternative government is operable, he may refuse dissolution. Next, the appointment of the members of Dewan Negara. According to Article 45 Clause 1, the YDPA has the authority to appoint 44 members of the Parliament, and according to the same Article Clause 2, the YDPA shall appoint members who, in his opinion, have delivered remarkable public service or achieved fundamental difference in the professions, commerce, industry, agriculture, cultural activities, or social service, or who are representative of racial minorities or are capable of representing the interests of aborigines. And the last legislative powers of the YDPA is that he have the power to remove disqualification from membership of the Parliament according to Article 48 Clause 3.
Assalamualaikum warahmatullahi wabarakatuh. My name is HAIFAA RAUHAH binti PUAD and my metric number is 1202151. Next, I'll continue with judiciary power of YDPA. The first power of YDPA in terms of judiciary is appoints judge of the Superior Court. According to Article 122b Clause 1 of the Federal Constitution, the YDPA has the power to appoint the Federal Court Judge, Court of Appeal Judge and both High Court Judge. The judges are appointed by the YDPA after consultation with the Council of Rulers and with the advice of the Prime Minister. Before appointing a judge, the Prime Minister also must consult with the Chief Justice. However, because appointments are made by the executive, the YDPA and the Conference of Rulers have little practical influence because the conference deliberates on judicial appointments while the YDPA acts on advice. The YDPA also can appoint any person eligible to be appointed as a High Court Judge to be a Judicial Commissioner on the advice of the Prime Minister after consultation with the Chief Justice of the Federal Court. The next power of YDPA is the power to grant pardons. Article 42 of the Federal Constitution expressly grants this power and specifies how it will be exercised on the advice of the Pardons Board. The right to issue a pardon is substantially established in the Article 42 Clause 1 of the Federal Constitution, which states that the YDPA has the authority to give pardons, reprieves and respites for all court-martial offences as well as offences committed in the federal territories of Kuala Lumpur, Labuan and Putrajaya, while the Yang di-Pertuan Negeri will grant the pardons in respect of all other offences committed in his state, meaning that the power of clemency is not vested solely by the YDPA as His Majesty's power is only restricted in the federal territories. The offences committed in the state was authorized by the ruler or Yang di-Pertuan Negeri of the state, such as a clemency appeal for an offence committed in Georgetown will be handled by the Yang di-Pertuan Negeri of Penang rather than the Yang di-Pertuan Agong. There are 4 conditions applied to the powers granted by Article 42 of the Federal Constitution, which are the YDPA as the head of the religion of Islam in those states has the right to issue pardons or commit penalties imposed by any Sharia courts in Malacca, Penang, Sabah, Sarawak or the federal territories which mentioned in Article 42 Clause 10, whereas the other 3 conditions are set out in Article 42 Clause 12. The conditions are where the Yang di-Pertuan Negeri of a state is to exercise powers over himself, his wife, son or daughter, such powers shall be exercised by the YDPA. The fourth one is the Conference of Rulers shall exercise the functions that will otherwise be exercised by the YDPA or the ruler of a state in respect of his son or daughter, and where the powers are to be exercised in relation to the YDPA, the ruler of a state, or his consort, the Conference of Rulers shall nominate a ruler of a state to execute the powers. In exercising the power to grant a pardon, the YDPA and the ruler must consider the advice of the designated consultative body, which is Pardon Boards, which consists of the Attorney General of the Federation, the Chief Minister of the state, and not more than 3 other members appointed by the YDPA. The third judiciary powers of YDPA is Proclamation of Emergency. Proclamation of Emergency is an ordinance under Article 150 of the Federal Constitution that was promulgated by the YDPA. The YDPAs must be satisfied that an emergency exists regarding Malaysia's security, economic life, or public order that cannot be managed through the normal administrative system and requires a proclamation of emergency. In short, the YDPA may declare an emergency prior to the occurrence of such a grave emergency if he believes there is an imminent danger. Article 150 is supported by Article 40 Clause 1, whereby the YDPA must act in accordance with the advice of the Prime Minister before declaring the state of emergency. In the case of the Chenpo and public prosecutor, the court held that the YDPA's power to pass emergency measures would be revoked once Parliament convenes. The example of proclamation of emergency can be seen when the YDPA declared the state of emergency following the Prime Minister's announcement on the imposition of lockdown, or known as Movement Control Order, back in January 2021 by the reason of COVID-19 epidemic. The restriction lasted for 2 weeks with the purpose to repress the spike of COVID-19 cases and to overcome the strain on the country's hospitals and healthcare resources. Lastly, the YDPA powers during the proclamation. While the emergency continues, the YDPA or any person authorized by the YDPA may take temporary possession of all or any part of any land, building, or movable property, and may issue such directions as may appear necessary or expedient in connection with the taking of the relevant property. During a state of emergency, the Parliament and state legislative assemblies will not meet until the YDPA determines that it is safe to do so. In other words, state and federal lawmakers will be unable to implement new legislation or change existing legislation during this time. However, the YDPA may promulgate ordinances when a proclamation of emergency is in operation in accordance with Article 150, Clause 2b. The ordinance issued under this power will have the same force and effect as an Act of Parliament and will remain in full force and effect until revoked or annulled. That's all from me. Thank you.
My name is Naisha Master Binti Hussein. My matric number is 1202147, and today I will talk about the limitations of the YDPA. According to the Article 34 of the Federal Constitution, it stated that Yang di-Pertuan Agong shall not exercise his functions as a ruler of his state except those head of religion of Islam. He also shall not hold any appointment carrying any remunerations and actively engage in any commercial enterprise. Based on this article, it also stated that Yang di-Pertuan Agong also should not receive any emoluments of any kind payable or accruing to as the ruler of his state under the provisions of the constitutions of the state or any state law. And the fifth one is, according to this article, Yang di-Pertuan Agong shall not be absent from the federations more than 15 days without the consent of the conference of ruler except on a state visits to another country. However, according to Article 34 Clause 8, it gives exceptions for the Clause 1. It stated that this clause does not prevent the YDPA in exercising as ruler of his state if it regards, first, to amend the state's constitutions or to appoint a regent or member of a council of regency in the place of any regent member that has died or incapable to perform the duties of the office. Next, for the immunity of YDPA, Before the amendment has been made, YDPA has the immunity to raise any offences or proceeding in court. Like in the case of Mild and Sultan Johor 1894, in this case, His Majesty was sued for breach of promise to marry. Then this case was brought to the court. Then there was a letter from the colonial office that stated Sultan of Johor was a sovereign ruler of the independent state. His relations with the Queen being those of alliance, not sovereignty or dependence, regulated by a treaty which limited the exercise of some of his sovereign rights. And therefore, with the proof of the letter from the colonial office to the court, it stated that the Sultan of Johor has the immunity from any legal proceeding. As nowadays, YDPA is not above the law. They has no immunity power towards civil or criminal actions. Since 1993, the immunity of YDPA from any legal proceeding has been removed as a result of the amendment of the constitutions. And based on the amendment, the YDPA will be liable for any actions of his personal capacity, and if there are any offense that has been committed, it will held in the special court as has been established under Part 15 of the Constitutions. However, the title of the YDPA still remains, although he is charged for the offence in the special court, but he no longer has capacity to carry out the functions of the role. As the conclusions, the YDPA is conferred with an extensive leave of powers. As the head of state, he plays an important role in ensuring that the administrations of the country is on the right track and it is in accordance with the federal constitutions. His Majesty works as a check and balance to ensure that the head of the three, which is executive, legislative, and judicial bodies, carry out their duty fairly and responsibility in the interest and welfare of the people. Although the federal constitutions limit his power by consistently directing the YDPA to act on the behalf of Prime Minister's advice, he had significant powers under the federal constitutions to ensure the stability and peace. The Yang di-Pertuan Agong has the authority to suspend Parliament and proclaim a state of emergency in order to protect security, economic life, and public order. Therefore, this is to guarantee the general public security, interest, and well-being. I think that's all from us. Thank you.